Do you believe requiring pornographic websites to adopt age verification technology for visitors and for all people featured on those websites in pornographic images, while imposing serious consequences for uploading and hosting non-consensual pornographic content, you think these are things that would help children?
I do think age verification, obviously with any piece of legislation, the words matter, but the idea of anything that will create friction between children and their exposure to pornography is an important thing, and age verification can be one of them. I think the danger here is to suggest, not to suggest, the danger here is what I see as tech directing things away from them often, right, as there's the solution, when we have to have a multi-tiered, multi-level approach. And that's why a combination of all of the acts you've talked about, the SHIELD Act, the Defiance Act, the Take It Down Act, the No Fakes Act, all together really provide much more protection than one or two approaches.
Klobuchar.
Thank you.
Thank you, Grassley. It is wonderful to be here and to hear your incredible testimony. Got through three of you, I think. And I first want to lead with you, Representative Guffey. Watching your family behind you, friends, how difficult this must be and how heartfelt your testimony was. I don't know how anyone can listen to you and not want to get something done here. So I want to thank you for that. You've described how victims of these crimes often suffer from mental health trauma. Can you quickly elaborate on why even the threat of the non-consensual distribution of explicit images can be tragic?
The threat is the most dangerous part of it. Not even the sharing of the images themselves are as bad of the threat, because you are taking your deepest, darkest shame or your most private moment and the threat of sending it out to complete strangers is complete vulnerability. I believe that in this country we've lost grace, and we have too often kicked people for the mistakes that they make, and we tell our kids that everything you do online will stay with you forever. Well, imagine if you just took your darkest moment and just posted it online.
Mm-hmm. Exactly. Federal. Why should this be federal?
Well, on a state level, I can tell you from passing or submitting legislation, passing legislation, I have submitted things such as the PROTECT Act, the App Store Accountability Act. We need help on a federal level because Section 230 is causing states to go at this 20 different directions.
Totally. Yeah.
And if 230 isn't going to fix it, and the states are fed up on how ineffective Congress has been, we're going to continue to try to go at it any and every way we can. But it would be a whole lot nicer to have uniform code across the country instead of just protecting children in one state.
Like you might do with the airplane seat rules that I just brought up.
Yes.
You don't have those state by state. That would be very difficult.
Yes.
To get any results. Mr. Pizarro, could you talk about why it's important that Congress pass these bills to give federal law enforcement tools? As you know, Senator Cornyn and I have this SHIELD Act, which is really important, ahead of its time, and then the Take It Down Act requires the platforms to take these down immediately, the non-consensual images, but also make sure that there is criminal liability for those that are posting it. Could you talk about why that helps federal law enforcement?
Sure. The challenge becomes in investigating between state and federal. There's a lot of gaps. So as an investigator, there's areas where I can't successfully prosecute or have the actual law in order to facilitate things. So especially if you go to rural areas where there's not a state perspective, where there's not really good laws, you're going to need that federal law in that aspect. So what SHIELD does, it fills that legislative gap in order for us to actually effectually do our jobs.
Mm-hmm. Good point. And another question on the fentanyl and the drug track. The DEA recently found that 1/3 of fentanyl cases they investigated had direct ties to social media. Others, like the National Crime Prevention Council, estimate that 80% of teen and young adult fentanyl poisoning deaths can be tracked back to social media. It's not a statistic, it's actual lives lost. How do the design of an algorithmic recommendations by online platforms contribute to the facilitation of drug sales?
Well, I could tell you this even going back when I first started, 'cause I'm not aging myself, but when there was cloned pagers and we were doing cartels, this is just the advent of technology. And with these tech companies and the AI algorithms, what they push, that's what they're going to see. So it doesn't matter. There is no, one of the things I asked Meta, I asked Snap, I asked a lot of these companies, can you explain your algorithms? No one can and no one will, because again, it's about business. It's about pushing that content, and that's what children are seeing. So that's why they're at risk.
Thank you. My last question of you, Ms. Goldberg. You have represented over 1,000 victims of revenge porn, just to give people a sense of those numbers. Of course, there's tens of thousands out there that never were represented. Can you discuss the challenges you face in getting justice for your clients and why passage of federal laws like the SHIELD Act and the Take It Down Act would make a difference?
Sure. When I started representing victims of revenge porn 10 years ago, there were 3 states that had laws, and everyone wanted to blame the victims and said you shouldn't have taken that picture in the first place. And it wasn't until we were testifying about it and actually making people realize that the liability needs to be in the hands of the offenders. There's a responsibility in being the recipient of it. But the bigger problem, though, was that the platforms were the ones that were distributing the content at scale. So, back in the old days, revenge porn could be, photocopied and put on a car windshield. But now with Snapchat and Google and Meta, one picture can be seen by millions and millions of people, and we need the uniformity, like Mr. Pizarro was saying.
Thank you. And I know my colleagues asked about Section 230, which I feel very strongly about, so I'll let that go. Thank you.
Senator Klobuchar, thank you.
Thank you, Chairman Grassley.
Senator Hawley.
Thank you, Mr. Chairman. Thank you for calling this hearing. Thanks to the witnesses for being here. Mr. Pizarro, let me just start with you. You've been working in the anti-exploitation space for a long time, both inside and outside government. Have I got that right?
That's correct.
And so you know the trends about what we're facing online, what kids are facing online, probably as well or better than anybody. Is that fair to say?
I would say pretty so.
Would you say that CSAM, child sexual exploitation or abuse material, would you say that there's getting to be more of it or getting to be less of it?
Oh, 100% more, like hundreds and thousands of more. I mean, I can't even percentage it.
Yeah, enormous amounts, right?
Yeah.
Here's a measure of it. In 2023, there were 104 million images and videos of suspected child abuse material uploaded onto the internet, compared to 450,000 in 2004. So 450,000 in 2004 to 104 million in the last full year for which we have data. Here's another statistic. According to the National Center for Missing and Exploited Children, the number of reports of child exploitation material went from 1 million in 2014 to 36.2 million in 2023. So in other words, it's just an enormous explosion. It's absolutely everywhere. So let me ask you about some of the remedies for this. If you are a parent, and I'm the parent of 3 young children, 3 little kids. If you're a parent of a victim of child sexual abuse material, and your child's image has been used, they've been exploited, it's been used online, and you've got companies who have hosted that content recklessly or intentionally or negligently, or they've done it. If you're a parent, can I sue them and get them to take it down?
Right now, no. You can sue them, but I don't know how successful you're going to be.
So if I went into court, if my kid is abused, their content is up online, we know the abuser, but we've got these companies that are hosting the content and making money on it by distributing it, and I go to the company. Let's say I go to the company and I say, this sexual abuse material, this is my kid. This is online. I'm reporting it to you. I want you to take it down. Let's say they don't take it down. You're telling me I can't go into court and sue them?
You're going to probably end up losing. I mean, and I think that's part of the problem.
It's a huge problem, is it not? You're exactly correct.
Yep.
You're exactly correct. The state of the law is I cannot go into court and hold these companies accountable. In fact, we had testimony just a few weeks ago of somebody sitting right where you're sitting, a parent, whose child was sold drugs, in this case, over one of these platforms, over Snapchat. This parent went in, reported it to Snapchat. Snapchat said, oh, well, we'll do our best. They did nothing. The parent said, I'm going to sue you. And the Snapchat executives laughed in her face. And they said, no, you're not. You're not going to sue us because federal law prohibits you from suing us. Let me just ask you this. In 2019, Facebook was fined by the FTC $5 billion. $5 billion with a B. And their stock price went up. Now, what does that tell you about what these companies fear? Do you think they fear these government regulatory agencies that almost never bring suits and almost never bring enforcement?
Oh, absolutely not.
Do you think that they fear lawsuits from parents who might get into court and get $1 billion or a $10 billion judgment?
For them, it's the cost of doing business, right?
Yeah, exactly. And they're willing to pay it. Facebook paid that $5 billion. Their stock price went up. They went right on doing what they were doing. But I tell you what they do fear, what they're absolutely terrified is, they're absolutely terrified of a parent coming into court and getting in front of a jury and holding them accountable. And that is why it is high time, it is past time, that this Congress gave parents the ability to do that. And I will just say again, for the approximately 3 millionth time in this committee, until Congress gives parents the ability to sue, nothing will change. These companies don't care about fines. They don't care about the regulations. In fact, the companies regularly come and sit here and offer to write the regulations. They say, oh, we're great public citizens. We'd love to help you write the regulations, Congress, and we promise to comply. We'll write them, and then we'll comply. They won't comply. They buy off the regulators. What they fear are juries. And this is why what Senator Durbin has done with his bill that we worked on together to give parents the right to get into court and have their day in court is absolutely vital. And I'm proud to be working with him on this. It passed unanimously out of this committee last year when he was the chairman, and I look forward to reintroducing it. We make it even stronger, even better this year. But I just say again, there is nothing more important than this Congress can do than to stop this, than to give parents the right and victims the right to get into court and to hold these companies accountable. Thank you, Mr. Chairman.
Thank you. Senator Hirono.
Thank you, Mr. Chairman. Thank you all for testifying. And Mr. Representative Guffey, our hearts go out to you. We have been here many times already. Yes, I agree that we have to do something about Section 230. But one of the things that Professor Leahy mentioned, and before I get to that, by the way, the enforcement is really important. And I just want to note that last week, when I was questioning Mr. Blanche, who is President Trump's nominee for Deputy Attorney General, I noted that is an issue that unifies the members of this committee, as you can see. That is why I was disappointed. It is non-answer to one of my questions. I explained that if we want to protect children, the last thing we should do is fire prosecutors who fight child exploitation and impose a hiring freeze that stops them from filling these vacancies. But that's exactly what's happening. So I think we should note the environment in which we are having this hearing. Moreover, there was a funding freeze briefly that cut off funding to Internet crimes against children task forces that fight child exploitation in every state. So child exploitation is a multifaceted issue, and I want to get back to Professor Leahy, who said that the states ought to have the right to go after child exploitation in court, and that they are not able to do so because of Section 230. Does that cover both criminal as well as civil prosecutions by states?
It has been interpreted that way. The states, and the way it's been interpreted is there's language in Section 230 of the Communications Decency Act which talks about that no state is not supporting a state law that is in contravention with Section 230 of the Communications Decency Act. So courts have interpreted that as, oh, that means you can't enforce your state criminal laws, which happened in the DART case, which was an attempt in the DART cases, and I assume it would happen in civil cases. under the C1 provisions of the statute.
Well, so you would support legislation at the federal level that would allow the states to enforce their own child protection laws?
100%, and I believe that my written testimony has a quote from the letters from the National Attorneys Generals laying out, again, for the third time, and again, speaking of unanimity, I believe there's, I don't know exactly how you can have over 50 attorneys generals, I believe it's the territories as well, all in agreement on this point.
And Representative Guffey and Ms. Goldberg, you would agree that we need to do something that would enable the states to support their own laws?
I would certainly agree with that. I think that's one of the tools in the tool belt. But yes, states need to be able to have the tools.
For Ms. Goldberg, you noted very briefly the Ninth Circuit and their decision in a case that you were involved with. Could you provide some background on the case and how Section 230 was involved and what you think that it demonstrates, this case demonstrates the state of the law around Section 230?
Yes. So that case is called Doe v. Grindr, and it accuses the dating app Grindr of advertising to children using Instagram and TikTok with child models in school settings and luring them onto the dating app. And as I said in my complaint, there's statistics that 50% of gay kids who are sexually active have their first sexual experience with an adult that they meet on Grindr. Now, Grindr has no age verifications and just absolutely turns a blind eye to the fact that there are so many kids that use their product and inevitably are recommended to adults. Now, I claimed that this was a defective product, and Grindr, because they knew about the problem, as I stated in my lawsuit, and we're refusing to institute any sort of age verifications. They were also condoning trafficking, and the case got thrown out by the district court, and that was affirmed yesterday by the Ninth Circuit. So I never got to go to discovery.
So it was thrown out because of Section 230 immunity?
Of Section 230, and because of the incredibly high knowledge standard of actual knowledge that they were imposing, which they didn't have to impose, but they imposed in the trafficking claim.
I support the general proposition, thank you, Mr. Chairman, that anyone who gets injured by someone else's actions ought to be able to pursue legal remedies, and therefore, I agree that we need to remove Section 230 immunity somehow, and still pay attention to various other unintended consequences that may flow from that kind of a change, but it's not where we ought to be because this is a growing problem. Thank you, Mr. Chairman.
Thank you, Senator. I believe I'm next. Representative, I'm sorry, but your boy's proud of you. You're doing good work.
Thank you.
My late father used to tell me that you'll never know love till you know the love of a child, and I didn't believe him, but I do now. I don't know what I'd do if something happened to my boy. I'm just so sorry.
Thank you so much.
Mr. Pizzurro.
Sir.
Social media is now a big part of childhood, isn't it?
Yes.
Can we agree that big parts of social media have just become cesspools of snark?
I can probably attest to that, yes.
Yeah. Can we agree that social media has lowered the cost of being an a-hole?
Yeah.
Can we agree that big parts of social media have become cesspools of sexual exploitation?
For sure.
And I assume you'd agree with me if I said that social media has lowered the cost of being a pedophile, hasn't it?
Absolutely. It made it easy access.
Yeah. You're familiar with the National Center for Missing Exploited Children's cyber tip line?
Yes.
Are the social media companies required to report instances of child sexual exploitation to the National Center?
Of what they see.
Okay. So the law says the social media companies have got to report these instances of sexual exploitation to the National Center. First, they have to look, don't they?
Yes.
Do they make any money when they look?
No, if you just look at the Apple statistics I gave before, at 36 million, there's 275 came from Apple.
But
so.
they're not paid to look.
No.
Okay. In fact, they want people coming to their social media platform.
More users, more money.
Yeah. They want eyeballs so they can sell them advertising. So for them to look is inconsistent with their economic interest, isn't it?
Correct.
All right. Now, once they look and they find it, then they have to report it to the National Center. Is that right?
That's correct.
Are they paid to report it to the National Center?
Absolutely not.
Okay. How many instances, I know this is a difficult question, how many instances do you think are of sexual exploitation of children are either looked for and or reported by the social media companies?
Well, I don't have NCMEC statistics, but I could tell you that there's a lot of ESPs that don't actually even report. So some over-report, some don't report at all. So that's part of the challenge. And then secondary, it's voluntary, right? So whatever they give them, there's no uniformity in data as well.
Yeah. What happens if they don't look and they don't report? Are they punished?
No.
Okay. You're familiar with the SAFER program?
A little bit.
Okay. It's a tool. They use AI to scan conversations and look for patterns that might be sexual exploitation of children. It's not the only algorithm out there. Do social media programs all use that?
I don't know how many do, but I don't know if they're using technology, but they should.
Are they required to use it?
Nope.
We've got to do something. This is my last question. Do you find it ironic that all of these people in big tech who dreamed about and talked about creating a utopia have managed to generate more hate and more harm than anyone could ever have possibly imagined, all to make money?
And lots of money they made.
You find that ironic?
Very.
Thank you all for being here. Senator Blumenthal, he's not only next, he's the only one left. But it's nice to see him.
Am I recognized, Mr. Chairman? Mr. Ranking Member, or are you presiding?
I'm
presiding.
the Chairman Blumenthal.
That may be the reason I'm the only one left.
Could be. I'm looking forward to your questioning, and I'm going to turn the gavel over to Senator Blackburn.
Thank you, Chairman Blackburn. Representative Guffey, thank you for being here today, and I think our hearts go out to you. I know I'm not the first to have said it, but your courage and strength makes an enormous difference. I know how strongly you supported the Kids Online Safety Act, and I am deeply grateful to you for your support and your activism in going to Louisiana, for example, seeking to talk to Representative Scalise and Representative Speaker Johnson on behalf of that bill. You did an article that I would like to have entered into the record, if there's no objection, and there seems to be none. When you went to see Representatives Scalise and Johnson, were you given an opportunity to talk to them?
No, sir. Myself or the other parents, we did meet with Representative Scalise's staff, which of course was in district at that time, but even coming up here to the Hill, unable to meet with either one of the representatives.
Would you like to meet with them?
I would love to.
Well, we'll try to arrange it for you.
Thank you, sir.
I'm hoping they'll hear from you. I'm hoping they'll support the bill this time. You agree?
I 1,000% agree.
Why don't you tell us as a parent, but also as an advocate and the author of that article, why you think some of the arguments made against COSA based on a supposed free speech thesis are incorrect?
I believe it's all follow the money. If you look at big tech and their lobby, and you look at the narratives that get put out there, and you look at the representatives that fight against it, and you follow the money and where it ends up, I believe that fear, and as an elected official, you know, I see it myself. You're often worried about what this will look like, and that's one of the reasons whenever I was presenting, I used the phrase that we have too many politicians worried about their next election instead of leaders worried about the next generation. And I believe that it's a false narrative that has been put out there. The argument has been had over and over, and people will agree with you, and then they will turn right around and share a false narrative.
I think the United States Senate has recognized that it's a false narrative through a strong bipartisan vote here, 91-3 in the last session. I'm hoping that we'll have that same kind of support again, and I thank my Republican colleagues, particularly Senator Blackburn, who has been such a steadfast partner in this effort. I'd like to turn to Professor Leary. I think I misattributed the article to Representative Guffey, but maybe you can expand on his response on that free speech false narrative.
Sure. Thank you, Senator. So first thing about free speech, well, first, as you know, I believe the article you're referring to, the op-ed, myself and other scholars wrote this piece. And it really dispelled these arguments about COSA, and really that we see again. In fact, if you look back in history, and it's interesting to look at what some of tech has said over the years. I can go back to 2014. They were making this argument. We can go back actually before that to 1996. They told us the Communications Decency Act was going to ruin free speech. Then they said it about the SAVE Act. Then they said it about Sesta Fosta. And lo and behold, we still have plenty of free speech. The thing to keep in mind with free speech is the First Amendment is that is an amendment designed to help inform us on how to handle these sticky issues. It is not a reason to not engage in legislation, and that it's being used in that manner. There's a distinction between speech and conduct, and specifically with COSA, COSA addressed conduct, not content. And so the speech argument was particularly misplaced with regard to that piece of legislation.
Thank you. In fact, COSA affects the conduct involved in product design. There's no more limitation on free speech than there would be if and when, because it does, the federal government regulates the safety of the design of an automobile or a toaster or a washing machine. If they explode, there is liability for it. It's not free speech to design a defective and harmful product. It's conduct. And there is no censorship, no blocking of content in COSA. Thank you all for your testimony today. Thank you, Madam Chair.
Thank you. And Professor Leary, I'm going to stay right with you for my question. I appreciated so much that op-ed that you had put together and the difference that you're making there, that it was not a free speech infringement. This is, as Senator Blumenthal said, product design, as you said, conduct, but we know the reason that Meta and Google and the groups lobbied, just millions of dollars spent lobbying against this, is because they have assigned a dollar value to each and every kid. and I think the dollar value is $270. And so our kids are the product, and it is so unseemly. To me, it is absolutely disgusting that they devalue the lives of young people in this manner. Mr. Pizzurro, I want to come to you. Senator Klobuchar and I have the National Human Trafficking Database Act, which would establish a database at DOJ's Office for Victims of Crimes and incentivizes states to collect and to enter and share their data. What we're trying to do is get a full picture of what is happening in each of the 50 states when it comes to human trafficking. And we have really had a tough time doing this and finding those people that are behind these human trafficking rings. I know your organization, Raven,
Yes.
has been supportive of the bill.
Yes.
I'd like for you to talk for just a minute about why having a national database is so vitally important to breaking this modern-day slavery apart.
Well, the more data we have, the more we're able to understand and see and react to. And I think that's part of the challenge is that as states, we're so fragmentized, so we're getting data from just certain areas. So the more data we're able to actually collect, the more likely we are able to put a comprehensive plan and understand how to go after, certain trafficking.
And I want you to touch for just a moment on the use of AI-generated CSAM, because what we hear from law enforcement is they're having to sift through so many images to figure out what is AI-generated and what is actual.
And that's a challenge. So right now, you can't, detective investigating something, I can't tell the difference between what a real image is and what is not a real image. So technology exists now. I can make those images whoever I want. I can make a child from an adult. And the challenge really becomes is now I could take your images off the ClearNet, off of social media, off of open profiles, and then turn that person into a child, or better yet, have sexually explicit images. The challenge is going to be we can't see it unless we have the software capabilities in order to actually do that, which again, we don't have.
I appreciate that, and Senators Coons, Klobuchar, Tillis, and I introduced the No Fakes Act to deal with AI-generated voice and visual likeness of individuals, and we think that this will play an important role in a remedy for AI-generated CSAM. Representative Guffey, I'd love to get your thoughts on that.
On the No Fakes Act, I personally love it. I've actually resubmitted the use of a bill very similar within the state. But I love the idea of using the name, image, and likeness. I think that is a very easy thing to hit. And as we talk about using AI-generated pornography, one of the problems that we have is stating that this is not a real person, therefore is it really a crime? Bills such as a name, image, and likeness protects our citizens as opposed to focusing solely on what the image is. It protects the citizens.
Let me ask you this, and congratulations on getting Gavin's Law passed.
Thank you.
Is there a way you can amend provisions of No Fakes onto Gavin's Law and begin to expand the protections there at the state level?
In South Carolina, unfortunately, no.
So it's going to be two separate. So you'll have to
Yes.
have a group of bills
Yes, ma'am.
that will do this. Okay, and I am over time. I am going to recognize Senator Schiff and turn the gavel to Ms. Moody.
Thank you, Madam Chair. Thank you all for being here. And Mr. Guffey, I appreciate your advocacy and want to express my condolence for the loss of your son. I can't imagine the trauma that you and your family have been through. But I appreciate your taking that trauma and using it to protect other families. I have not had a chance as a new member of the Senate to really study the multiple approaches of the various bills, although some I've supported in the House. But I wanted to ask you, Professor, we established Section 230 for the reasons I think you implied, which is it was a nascent industry. They urged us to do so that we would not stifle innovation. They also made the argument that without 230, they would not moderate content because they would be sued if they did, and this would encourage them to moderate content. Well, there may have been a time where they moderated content, but those days seem to be over. It certainly wasn't enacted because it was believed necessary for the First Amendment. First Amendment stands on its own 2 feet. In the absence of 230, companies could still plead a First Amendment defense to any case. What is your preferred approach? That is it a repeal of 230? Is it changing it from an immunity to some form of defense? Is it to cabin 230 in some way by narrowing the scope? What are the merits of the various approaches?
Thank you, Senator. I would say that it's important to, a couple of things. I would say that there was discussion in the deep background about this free internet nascent industry. And when we look at the policies and the findings at the beginning of Section 230 of the Communications Decency Act, there is languages to that. But I would repeat, the overwhelming background and discussion was about the child protection piece. And therefore, I think that the concern, I think that better than repealing the entire thing is to keep the C2 language, which gives a cover, gives a protection to a platform if they do, and specifically, if they remove anything they consider to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. That will protect them. That's all they need. They do not need C1, which is what has been turned into this de facto near absolute immunity. I think also adding the state's ability to proceed is an important thing. I think outside of 230 is holding them liable when they host this material, like that's has been discussed at length as well. So I think that those and some of the other things that I've listed, but I don't want to use up too much of your time, all work together to respond to the complex crime.
And counsel, in your representation of clients in this area, what do you believe would be most helpful in terms of making sure that you can get the discovery you need and that that we have established the right protections and the right burdens in terms of the platforms and the pipelines?
Thank you. I agree. We are long overdue to just abolish Section 230. But what's important is that clients need to get into discovery so that they can actually know what, the extent of the problem. And the only way we can do that is if the standard is reasonable for parents to plead. If we have to show that the company knew about that picture or that exact victim, that exact perpetrator, there's no way a client's going to be able to overcome a motion to dismiss and get into discovery. So we need to actually have standards like negligence, which the law already affords in almost all causes of action.
So let me ask this question. I don't think there's any doubt that if the companies devoted their technological capability to trying to solve this problem, that they could make enormous gains. They wouldn't be able to eliminate the problem altogether, but nonetheless, they could prove very effective. What would you propose the new standard be then? That is, if it's not going to be possible to completely do away with this, the standard can't be perfection. How would you define the standard of care that you would expect the industry to follow, given that it hasn't had to follow any standard with the protections of 230?
And if you could just quickly answer that.
Sure. Well, these are products, so strict liability should apply here. If these companies have created a defective product, then all users should be able to sue them without having to even prove a duty if the product injured them.
Thank you.
Thank you, Senator. Appreciate you being here today. I have been so impressed with this committee. I'm a senator all of 4 weeks, so get ready. I bring to it with an array of passions I have acquired, not just as an attorney general, but as a mother of a teenager right now. And I'm so impressed with the topics that we have focused on, and specifically this one. It was shocking to me that the Senate was able to move forward pretty unanimously on some protections for children, and they ran right into the House that did not go along with some of those things. And I'm hoping that we can change that. As Attorney General, obviously, I fought in court against many of the platforms. I investigated platforms for harms to children. I am the mother dealing with this now. In fact, I tell people all the time, it is really hard to be one of the first generations of parents trying to parent children, and we don't understand what we're doing because we don't understand the technology to the degree they do. In fact, when I'm going through some of the controls, I often have to ask my kid what that means, which seems to defeat the purpose. But here we are. And while I can break down what we're addressing today by privacy concerns of children, certainly, harm to children, whether that is mental affects, addiction, or materials that they never would have been exposed to in the past, but they now have ready access to. One of the things I want to talk about quickly is the access to our children by predators and bad actors. I think this is this third lane that we read about repeatedly in the paper every single day. In my state, from doctors to predators to you name it, they are getting access to our children, and parents in the past could lock our children's bedroom doors and know they were safe at night, but that is not the reality anymore. In fact, in my own child's school, there were 5 teenage boys. A woman was arrested for posing as one and luring them and molesting them online, I think using Snapchat and TikTok. And of course, when you engage with the platforms, they will often deny that this is happening. But it is happening. And the best people that can represent that are the parents, where it's happening to their children in their homes while they thought they were safe. And so I really commend you as a fellow parent, Mr. Guffey, for taking your pain and channeling that into just frustration and anger, because that is what is going to get the attention of lawmakers. I mean, we've tried to get the attention of the platforms. We've talked a lot about what needs to be done to force some restrictions and them acting on their own. But we need to talk about what needs to be done through laws. And what I'm specifically concerned about, and I would open this up to whoever wants to answer this question, what is the thing that we can do as lawmakers right now to stop predators from getting access to our children?
I'll go.
Let me start down there and then we'll come to
I want to use this as an example because the comment was made that we essentially have different laws for the outside world than we do from the inside world. If I had a storage facility and I stored only guns in there, and you as Attorney General, and someone was breaking the law, and I said, okay, well, the majority are law-abiding citizens, but we also have terrorists, and we're going to store guns for criminals. And if I told you that you had to have the digital ID to get into that locker, you'd think that's ludicrous. But that's exactly the way that we treat CSAM. I mean, to me, I believe that if you're housing CSAM, you should be held responsible. But nothing is going to change until we open up civil liability. These are the world's richest companies since the inception of man, and yet they are immune.
And I'd say that if you have designed a product where you are exposing children to predators and you can't stop that from happening, then it's a defective product. And all a parent or a victim should have to do to be able to sue you is just to show that you know about the problem and the extent of it.
And in your experience, and I understand that this has happened, when parents have demanded and shown that this harmful material is online and demanded that they take it down, they've now told them about it, they know about it, and there have been refusals to take it down. Absolutely.
And those cases get thrown out of court because the online platform says, well, I didn't know about that specific incident. You know, of course they're not going to know about that specific incident, or they're going to say, I didn't intend to harm that exact child.
And Mr. Pizzurro, I know you have law enforcement experience, and I'm grateful for that. Thank you. My husband is career law enforcement. understanding that predators can now get to our children through online platforms and online, what is the number one thing you would recommend to prevent that we can do as Congress?
Device-based age verification. You mentioned parental controls. If there was a framework for a parent just to shut the spigot off and make it easy rather than go through 25 different apps, the companies have this. We can stop it at the device level. That's where we prevent children from getting onto some of these images and offenders getting access to those children.
Thank you. And since I am the acting chair, I don't want to exceed the boundaries of time. So I will turn it over to Senator Whitehouse.
Thank you. And I understand that I've been given permission to close out the hearing at the end of my questioning. So I know you have another place to be, so don't hesitate to go where you need to be. First of all, Ms. Goldberg, you said that repeal of 230 was long overdue. I'm hoping that that day is coming fairly soon and that a bipartisan bill to do just that will be filed by a group of members from this committee before very long. As you also pointed out, there are standards by which to evaluate the conduct or misconduct of these big platforms that the law already affords. And everybody else has to abide by those same standards. If you're a radio station, if you're a newspaper, if you're a manufacturer, if you're an individual, some of them go back to the English common law that came over with the first settlers. And the idea that what Representative Guffey described, I think, quite well as institutions that are the richest since the inception of man shouldn't be bound by the law. I adore Ron Wyden. I think he's a wonderful senator. He put Section 230 in when these platforms were in people's garages. And they've gone from that to being the richest companies since the inception of man. I'm not going to forget that phrase of yours, Representative Guffey. I like it. With no change in Congress's response to the original rationale for having that Section 230 protection, and also repeated grotesque failure by these entities to police themselves. It's not as if we're dealing with a array of platforms that have a demonstrated record of meeting the public interest in the safety of their product. Not at all. As a lawyer to lawyer, Ms. Goldberg, talk a little bit about when the Section 230 defense first kicks in and what that means in terms of you and your clients actually being able to get discovery, to take a deposition, to find out the truth of what actually transpired.
What happens is that I file a lawsuit with all my facts, with everything that I can know, even though there's so much asymmetry of knowledge. Like, I don't know the extent to which the platform knows about the exact problem or the overall problem. I can just base it on what's happened to my client if they're alive. Otherwise, I have to go through their parents. So immediately, within like 30 days,
you file your complaint.
They file a motion to dismiss, saying, we're just a publishing platform. We're not a product. This is just speech. And then they attempt to get it dismissed. Oftentimes, judges will do it without even oral argument. And then we never get into discovery. So we never get the opportunity to even show or know exactly the extent to which the platform has been tolerating and making money off of this exact harm. We don't have any information about other similar incidents, nothing.
So it's a vehicle not only for evading responsibility for bad acts, but it's a vehicle also for covering up what actually took place. It would be slightly different if the Section 230 dismissal motion was something that you made at trial, for instance.
Yes, and
so I have a full chance, but not even that.
I also believe that even more terrifying to tech than facing a jury eye to eye is the discovery. It was the discovery that made Omegle shut down. I had 60,000 documents showing all these other similar incidents of child sexual abuse, and they shuttered their platform because they had no defense.
Discovery is a beautiful thing. Senator Padilla.
Thank you, Mr. Chair. Mr. Guffey, I just want to begin with you and let you know that my heart goes out to you for you and your family's experience, and I really appreciate your willingness to be here today and to share your testimony.
Thank you.
I want to draw my colleagues' attention to the threat presented to minors by a relatively new consumer product, character-based AI chatbot apps. Many of these services have been flooded with age-inappropriate chatbots, which may cause young users to be exposed to sexual or suggestive AI-generated imagery or conversations. As a father of 3 school-aged children, this is personal. Further conversations with these chatbots can end tragically, as we've heard reports. Since 2023, at least 2 individuals have died by suicide following extensive conversations with AI chatbots. So the threat, colleagues, the risk is real. Mr. Guffey, how would you recommend that this committee begin to think about or think through the risk posed by this emerging consumer product category?
Whenever it comes to AI, I would have to lean more on some of the other panelists up here on their expertise when addressing chatbots. Chatbots is something new that I have just started really looking into, but on the legal side, I'm not an attorney. So I'm an angry parent that tries to throw it against the wall, whereas the attorneys are the ones who have to say, this is what will hold up in court, this is what will not.
Well, we've had to figure out the legalese, but I do think you have the most important voice here, given your experience. I mean, the chatbot piece is just the next iteration
Yes, sir.
of this technology. We know what technology was when you and I were much younger.
Everything.
What children have to contend with today, we can only imagine what's coming.
Well, and that's the exact problem. It's not just the problem, that's the problem of today, but it's as tech is evolving, our laws don't move fast enough to keep up with. And I believe that having that liability and being able to hold these companies responsible for what they are presenting, if we instead of taking online services and treating it as a service, if we can simply treat it as a product, then we can hold them to consumer protection laws.
Senator, if I may, I think we should think about the international context in which this is playing out, because the recent AI summit in Paris was called the AI Security Summit rather than the AI Safety Summit, which had taken place in the UK and I believe in Korea. And there's been a shift away from the prevailing thought that we must make these products safe. And instead, and particularly this administration, is urging the vast and quick expansion of these tools. And I think you have a role, and your colleagues have a role, to bring that focus back. And I dearly hope you do.
Ms. Goldberg, you seem anxious.
I do. One of my close friends, Matthew Bergman, is actually litigating a case against Character AI where the bot encouraged addictive behavior and ultimately led the child to die by suicide. And I think what we'll find is that there's a possibility that courts will perceive this speech as the corporation's own speech, and that in that case, Character AI is owned by Google, and that it won't overcome a Section 230 challenge.
Okay, very good point, actually. So what I would do, just in the interest of time, is invite all of you to respond to the same question after the hearing as part of our questions for the record, because I do want to get to at least one more topic, and I understand Senator Graham is on his way back as well. Last Congress, we had a hearing very similar to this, but instead of you 5 sitting in front of us testifying, it was actually the CEOs of the 5 largest social media companies testifying to the committee. And I had the opportunity then to ask them each about the parental tools that they offer, or didn't, but I think all of them have offered some sort of parental tool to help parents, help minors safely navigate the use of their respective services. I asked them to describe what those tools were, and more specifically, what the adoption and use rates of those tools were. Because you can have tools and protections out there, and you can debate whether it's sufficient or not, but if people aren't even utilizing them, then kind of what's the point? And sadly, they either didn't share how widely used these tools were, didn't provide the data, and they're all very big into data, or what data they did show demonstrated to us that the usage rates were actually very low. So the conclusion, unavoidable, undeniable, is that the industry isn't doing enough to let parents know what resources are available and aren't investing enough into understanding why these so-called protections aren't being adopted at greater rates. Mr. Balcom, in your testimony, you observed that these controls would better serve minors and their guardians if they were standardized, interoperable, and unified between apps, devices, and brands. How do you think we can make that a reality?
Well, I often use the example of the automobile industry. Back in the 50s and 60s, if you got out of one car and into another, you may not necessarily know where the blinkers are or the light switches were. Even the logos for those were different in different car makes. Well, laws came into place in the 60s, and in fact, now when you get into a new rental car, you know exactly where the indicators are, you know exactly where the lights are, and the symbols are all the same. Well, I'd like to see the industry come together, ideally voluntarily, but if not, perhaps with some coercion, to standardize the ways in which parental controls and online safety tools, which, by the way, are the ones that teens and young people use to stay private, to report, and to block, oftentimes without even their parents' knowledge. But in other words, let's have a standardized way of keeping our kids safe, and that teens can keep themselves safe, that is not as confusing as we got at the moment.
Yeah, industry standards. It's not a new concept, and it tends to happen one of two ways. It either gets imposed by some level of government, and then industry comes away kicking and screaming, or they can actually live up to their responsibility and come together as an industry and put forward a model that is transparent and that either works, or at least we can measure and hold them accountable when and where it doesn't. I know it's been a long morning for all of you. Very, very much appreciate your participation in today's hearing and the work that you do and the perspectives that you've offered. Told Senator Graham is not coming after all, and so it falls upon me to not just thank all of our witnesses, but remind folks that the hearing record will remain open for 1 week for statements to be submitted into the record. Questions for the record may be submitted by senators by 5 p.m. on Wednesday, February 26th. Unless there's anything further from the nameplates, then this hearing is adjourned.
Thank you.